Carr Dubh wind farm under Section 36 of the Electricity Act 1989 and Section 57(2) of the Town and Country Planning Scotland Act 1997. My name is Philip McLean and I'm a reporter with the Scottish Government's Planning and Environmental Appeals Division, or DPEA. I'll report to Scottish Ministers with my recommendation on whether the application should be approved or not. The topic for this morning's hearing session is energy and planning policy. The main purpose of the session and of all the sessions in this inquiry process is to make sure that I understand the positions of each participant on the topic in question. Where there's disputes, I need to be clear on the reasons for that dispute so I can properly set these out in my report to Ministers. A few initial housekeeping matters to run through. This meeting is being recorded and broadcast live, and Stephanie from our IT team will remain on hand in case of any technical difficulties. But hopefully we're all up and running well today after a few hitches yesterday. In due course, the recording will be available to view on our website. In accepting the invitation to this meeting, you have agreed to being recorded and to the use and storage of images and sound recordings and any information contained in them for webcasting and training purposes and for the purpose of keeping historical records and making those records available to the public. For data protection and privacy reasons, we request that participants or observers do not take any photographs or other recordings of their own during the session. Please mute your microphone when you're not speaking and just raise your hand or wave if you want to attract my attention to contribute at any time. And please ensure mobile phones are on silent. I'm physically located in the DPA office in Falkirk. I'm not expecting any tests of the fire alarm system today. As there are participants here today who were not involved in yesterday's landscape and visual hearing session, can I now invite each of today's participants to introduce themselves and their teams, starting with the applicant, please.
Good morning, sir. My name is Colin Innes, and I'm a partner of the law firm of Shepherd & Wedderburn, and I appear on behalf of the applicant at this hearing session. I'm accompanied this morning by personnel that were here yesterday, but I'll introduce them again. David Bell from David Bell Planning will be the principal witness today, and he will be giving most of the evidence. And I've also got Scott Balance from Statcraft, who are the owner of the applicant. And I think we left one matter over from yesterday, which I'll deal with after we've done the introductions. Thank you, sir.
Thank you very much. And the council, please.
Morning, sir. My name is Maurice O'Carroll. I'm an advocate at the Scottish Bar, representing Argyll and Bute Council. I'm accompanied today by Mr. Tim Ferguson of Ferguson Planning, with the principal witness this morning on behalf of the council, giving evidence on planning matters. I also have a matter over from yesterday, which I will address you on in a short while.
Okay, thank you very much. I'll pick up on those points shortly. Just to say, I made a number of remarks when I opened the inquiry yesterday, and I don't intend to repeat all of those in full, safe to say that they still apply. Since we do have a participant today who was not involved in yesterday's session, I'll just briefly cover a few key matters. The agenda for this hearing session was circulated about a fortnight ago. It is on the DPA website under the case reference WIN-130-10. Participants will be familiar with the format of a hearing session, so I won't explain that again, but it is worth reiterating that my role is to understand and test parties' positions. So if I'm questioning or probing on a particular point, this should not be taken as indicating that I necessarily disagree with what's been said. We'll be working from electronic devices or paper copies. I might sometimes just need to ask parties to pause to ensure we've all located the relevant parts of a document. Hopefully we can progress quite quickly through this morning's agenda. Depending on progress, we can take a short break at a convenient point at around 10:30 or 11. As discussed yesterday, there's potential to bring the conditions hearing, which is scheduled for this afternoon, bring that forward if we finish this morning's sessions promptly, but we can see where we are when we get to the end. So before we move on to the agenda then, I'll invite each of the parties to raise the points that they wanted to at this stage. I'll start with the applicant, please.
The leftover matter yesterday was just Mr. Vance was going to just update you on the public consultation that was undertaken. As I don't think other parties have got the same documentation. It should take a relatively brief period of time, but I think it's probably best to do it in public rather than just by document. That's okay, sir.
Yep, that's fine. Shall we take that as the sort of first agenda item then before we move on to the planning policy? That's fine. Mr. O'Carroll, can I just ask you for the point that you wanted to raise, please?
Yes, thank you, sir. Likewise, it's a matter just from yesterday, and that is that you asked that you be provided with further information with regard to the Glass Bar wind farm proposal, which has been granted permission. And I've asked my planning witness within the conditions planning witness within Argyll and Bute Council to produce documents that will provide you with further information on that. She tells me that she'll do that this morning and that will be circulated to you and all the other parties once it's received by me.
Okay, thank you. That's very helpful. Appreciate that update then. So before we move on to the start of the hearing, and we'll take the point that's just been mentioned first, are there any other questions or procedural points? No. Okay, in which case we will start then with the matter in relation to public consultation. So I'll invite the applicant just to give us a summary of that, please.
Good morning, sir. Just following the point made by Mr. Innes yesterday regarding the no public objections that were received as part of the statutory consultation process, just thought I would give some figures regarding the methods in terms of engagement for pre-application and post-application as well. So the pre-application consultation report highlights all our activities, and I believe you have that in front of you. At the moment, it's not a core document.
I do have that, yeah.
I'll refer to some paragraphs just for the benefit of other parties as well. So with regards to the first exhibition, that was an online exhibition only due to the coronavirus in terms of the global pandemic and the restrictions were put in place. But in terms of the methodology, it's detailed within paragraphs 4.5 to 4.14. So we wrote to community councils and gave a notification letter inviting to engage with the online public exhibition. We wrote to elected representatives that included the local MSP and ward councillors of Oban North and Lorne and host neighbouring ward members of Mid Argyll. We put newspaper adverts in the Oban Times and the Argyllshire Advertiser, and then we actually wrote to 1,480 homes and businesses. And in terms of engagement with that event, there were 122 website visits, and we also received 54 feedback forms. And in total, there were 65 interactions, and this included additional consultation efforts, which included callbacks and emails as well. And those numbers are outlined in paragraph 4.19 of the pre-application consultation report. The second exhibition, which occurred in October 2021, that was a hybrid engagement method, so that was online and in person. Again, those details are set out in paragraph 5.10 to 5.18 of the pre-application report. Again, same methods were undertaken to notify, and again, just to draw your attention to numbers, we wrote to 1,395 homes and businesses as part of that effort. In terms of physical attendee numbers, we held the physical events in Ford, Dalavik and Inverary. We had 5 visitors coming to Ford, 10 coming to Dalavik and 17 visitors coming to Inverary across the events. In terms of website visits, we had 273 and we received 64 feedback forms. And in total, including those feedback forms, we had 125 interactions. In addition, this doesn't form part of the pre-application consultation report, but I thought it might be worthwhile drawing it to your attention. Following the submission of the application, we held 4 separate drop-in sessions. The purpose of that was to answer any questions of the public in terms of we had hard copies available, so any questions on the submission documentation, but to actually direct members of the public of how to make representations to the Energy Consent Unit. So across the 4 events, we had 33 people who dropped in, and they were held in Ford, Alnwick, Secure, and the Lochfine Hotel in Inverary. And just to, again, probably ease just the full consultation effort, within the pre-application consultation report, within table A.1, it summarises a full timeline of consultation efforts which we took in advance of lodging the application. So I hope that answers your question in terms of methods we undertook to consult.
Okay, thank you for outlining that. I'll review the pack reports in due course. Is there anything that you would like to respond to, Mr. O'Carroll or Mr. Ferguson, from the Council's perspective on what's just been said? You're on mute, Mr. O'Carroll.
Sorry, I've got, in relation to the attendee numbers of the second exhibition, the hybrid one, I have 10 Delavic, 17 Inverary. I didn't pick up the Ford number, please, Mr. Valance, if you wouldn't mind telling me again.
Sorry, Mr. Carroll, we had 5 doctors who came to bed.
That's it, thank you.
One from me, so if that's what you're looking for, sorry.
Okay, that's fine. If the council doesn't want to make any specific comment, then that's fine. We can move on now to the points listed on the agenda. So in which case, item 2 is energy policy. So the hearing statement set out in some detail the provisions of energy policy that parties consider to be relevant in this case. And in broad terms, there appears to me to be a high level of agreement on this. However, I wanted to confirm whether there are any areas of disagreement that would be useful to discuss today. So I don't have a specific question on this, really. I'd just like to invite parties to raise anything in the other party's hearing statement that they disagree with regarding this matter. I'll invite the council to go first, please.
Thanks, sir. No, in relation to Mr. Bill's hearing statement, we broadly agree to his hearing statement. In the main, there's agreement in the overall compliance with general policy. The council's objection related to landscape impact matters, which was covered by Miss Anderson yesterday, and we don't intend to go back into that. Just one general observation that might be covered in the LDP session later was with regard to the LDP policies in, I think it's section 5.2 or table 5.1 of Mr. Bell's hearing statement. It was just a passing reference or something we can discuss later with regard to policy 02 of the LDP. Didn't appear to be in the table, which I think is cross-referenced in the report of handling by the case officer. Thanks, sir.
Okay, thank you. I will just note that point to pick up later under agenda item 4. Can I invite the applicant for any comments on energy policy? Thank you.
Thank you. Sorry, good morning. Good morning. I think, yes, like Mr. Ferguson, I think there's a broad level of agreement. There's just 3 points I'd like to raise. Some of them are observations more than disagreement. The first one was just about the national development status of the application. That's a planning matter, but it's also an energy policy related nature. There's a link between the two when you read in and for it. I fully accept Mr. House maybe just that and notwithstanding it, I don't think he's referenced it in his hearing statement, so I'm not emphasising, but it's something I'd like to highlight because I didn't see a reference to it, and that's clearly important for the planning balance. That's the first point. Second point was that's paragraph 4.38 of Mr. Ferguson's hearing statement, where he states, in the context, I think he's referring to the Arkonnell wind farm, which is a historic scheme, where he says there's not been any major change to landscape policy should be applied. So this may be something we come on to, but Arkonnell was several years ago, pre-NPF4, and our position is that there has been a tangible change in how landscape should be considered in the development plan. So to give just an illustration of that, we've clearly got for onto, but in the onshore wind policy statement, which I don't know the CD number, sorry, 2.8. There is a section on NPF4, which as we know is to the development plan now, and section 3.6 of the onshore wind statement, page 19, talks at paragraph 3.6.1 about targets and that this will require taller, more efficient power plants. And then it says this will change the landscape. Underlined. It's very rare to get underlining in a policy document. And this isn't part of the development plan. The Scottish Government are telling us here that landscape will change. It needs to be anticipated. It's being clearly signalled. And when you look at the immediate decisions that came after NPF4 came in, Shepherd's Rig, Ashtarrick being 2 relevant examples, where the reporters had to prepare supplementary reports to reassess the schemes against NPF4. In both cases, they decided that they would change their position from a recommendation of refusal to the ministers to one of recommending approval based on landscape matters. And that's perhaps just an illustration of how force of NPF4 has come into play as part of the development plan in terms of landscape policy judgments and how the matter of acceptability is treated. It's not to say in every case development would be approved, but it's just an illustration of there has been, we would say, a change in that regard. The third point is what Mr. Ferguson states at 6.3 his hearing statement with regard to the Electricity Act 1989. He says that Schedule 9 provides direction that development should take due regard to preserving natural beauty and sites of historical interest. It seeks that all necessary mitigation measures are undertaken to ensure impacts on the countryside are minimised. Now, firstly, our position is that Schedule 9 does not apply to the applicant. The applicant is not a licensed generator at this stage. Furthermore, it's not a development management test in any form. That's been made clear by case law. It is, we would say, an environmental duty that applies in certain circumstances. And putting it simply, if the duty does apply and an environmental impact assessment has been undertaken competently, then there will be compliance with that provision. Now, the reference to mitigation in Schedule 9 is perhaps slightly broader. It talks about reasonable mitigation. That does not mean that every effect has to be mitigated. Otherwise, at the end of the day, you may not have a project, or you'd have a minimal project. So I just wanted to highlight that there's clearly a matter of law at play here, and that's not for me perhaps to go into in detail on that. The advocates may do so. But I just wanted to flag up that point on Schedule 9. Thank you.
Okay, thank you. Would the council like to respond to what's just been said?
If I could just jump in there quickly on that last point. Mr. Bell is quite correct in his characterisation of the duties under Schedule 9. For ease, these matters have been set out succinctly and correctly in the Statement of Agreed Matters, sir. I'm just trying to find the actual paragraph reference to it. Essentially, what it comes down to, let me just find the actual section there. I'll just get that, and I'll refer you to a particular paragraph. It's 5.3 to 5.2. Again, correctly states that the duties under to the persons promoting wind farm schemes doesn't affect the current developers because they're not license holders or persons exempt in terms of Schedule 9 and 1989 Act. 322A refers to the ministers. It's also correct that it doesn't have to ascertain that those environmental matters are safeguarded, merely that they have regard to them. That's all correct and that's all agreed. The one point I think that does arise from that, though, is that the information that is provided to allow ministers to undertake their duty under 3.2a of Schedule 9 is, of course, from the EIA and evidence that's then provided to the ministers. And effectively, they need to be provided the information by the applicant in order to fulfill that duty that they have themselves to have due regard. And there's case law to that effect that I know Mr. Innes is very familiar with. So that being the case, that in terms of then mitigation, those are the matters that are stated there, and that is the duty that's applicable to it. The only other point I'd make in relation to points 1 and 2 of Mr. Bell's comments is that I think he accepted that those are planning matters, and I think just to be clear that what Mr. Ferguson was responding to was the questions of energy policy. He did mention the onshore wind policy, obviously that's energy policy. And the matters then purely of energy policy applicability are matters with which the council does not take issue. Thank you.
Yeah, again, I would probably agree with what Mr. O'Carroll says, and again with regard to paragraph 4.38, item 2 that was raised. I believe that yes, time has moved on, and we do agree with the significant weight given by MPF 4. And as I said through the statement, and the council have said numerous times, there's general support for the wind farm in this location. However, obviously, as you heard yesterday, sir, with regard to considered landscape impacts and significance of that, which was again part of the reasons for refusal at O'Connell. The updated policies within the MPF4 and LTP2 are broadly the same and required to be assessed and mitigated where necessary. Thank you.
Okay, thank you. Any further responses from the applicant on that before we move on to the next point?
No, thanks, sir. That's fine.
No. Okay. You'll see from the agenda 2B, I just had a slightly more specific question, which is just to ensure that I understand what the applicant means in the hearing statement in reference to the need case. It's mentioned a couple of times, paragraphs 2.1.1 and 2.8.9 Just trying to understand, is that the same thing as a proposal benefits in terms of energy generation and net zero targets, or is it something slightly different?
Do you want me to go first on that?
Yeah.
Just to
Yes, please. Yeah.
I think there is a distinction. I think for a national development, there is a statement of need, and that's NPF 4, page 103, where there is a statement on need, where it's, just to keep it short, it states additional electricity generation from renewables of scale is fundamental to achieving a net zero economy. Within net zero, there's clearly targets, and there are, as we know, targets for onshore wind deployment, UK level and Scottish level. And in terms of benefits, I think they are important to look at distinctly in relation to policy 11 of NPF4, where we are directed to take into account the contribution of a development. And there's other reference to benefits in policy 11, and that requires us to look at some of the detail of those. And indeed, when we will perhaps look at a few Section 36 decisions later in the session briefly about how the Scottish ministers treat benefits separate from the matter of need. That will clearly go to matters of weight as well that we slightly touched on yesterday. My position would be that if we're dealing with a national development, then the benefits that would arise would be of national importance. Thank you.
Okay, would the council like to respond to that?
Just in very short terms, sir, the council, as within my hearing, have agreed to support renewable energy generation and how it helps towards net zero targets. We again appreciate that there's no defined cap in terms of the UK targets for Scotland. So, largely in agreement with Mr. Bell on the matter, and obviously Scotland is performing well across the UK in terms of energy need. Thank you.
Okay, thank you. Are there any further points just in relation to energy policy before we move on to item 3, where we move on to NPF 4? No. Okay. So item 3 then, National Planning Framework 4, has been touched on very briefly already. Essentially, I understand that parties differ on whether the proposal is supported by NPF 4 overall. Just like to explore the reasons for those different positions, and starting with policy 11 as the main policy for renewable energy proposals. So I've got a series of questions or topics to run through, as you can see on the agenda. The first of these is to ask parties for their views on whether the proposal maximises net economic impact, which is referenced in policy criterion C. My understanding from the applicant's submissions on socio-economic benefits, which is core document 7.1, is that the applicant considers the proposal does do this. So perhaps it might be best to start by asking the council for its view on this, please, and then I'll invite the applicant to respond.
Thanks, sir. I think, again, from the council perspective, it is accepted and not challenged in terms of the proposal having a positive or net economic benefit or impact. The question, I guess, is about how do we define maximising that benefit. I think there was comments with regard to the socio-economic core document 9.1, but I understand that the applicant has addressed that they've outlined details of the detail of the economic benefits within the other submissions within the EIA. I think Mr. Bell can possibly maybe clarify that matter, but as I say, the council is in charge and generally in agreement with what's stated.
Thank you. Don't need to sort of repeat the written submissions that we have, but I will give the applicant an opportunity just to comment on that before we move on.
Yeah, thanks, sir. I think that's a very fair statement of Mr. Ferguson. I'd agree with him. on the way that it's been approached. I think for planners, we found it a slightly tricky topic because there's been no guidance on the word maximised. But when we look at all the Section 36 decisions issued by ministers, they've all, in all cases, I think, focused in on what are the conventionally reported socioeconomic benefits within typically an EIA report chapter. And we have that in EIA report chapter 13, CD 1.15. And that's, you can see the figures in there.
Okay, thank you. That's full. So we'll move on to policy criterion D. I just wanted to clarify views on whether that is applicable or relevant in this case. It states development proposals that impact on international or national designations will be assessed in relation to policy 4. The statement of agreed matters indicates at paragraph 7.2.3a that both parties do consider this criterion as relevant. And I understand from the Council's hearing statement at paragraph 4.33, which is talking about this cross-reference to policy 4, that the Council may be suggesting that other designations should also be considered in the context of this criterion. In other words, not only international and national designations. So I'll maybe start by asking the Council just to confirm if that's a correct interpretation of the Council's position.
So I think there was a slight confusion on this one. It is said with regard to part D that there is no international national designations within the study area, as it were. The statement was making cross-reference to policy 4, which it was just in passing. So I'd probably retract that element soon.
Okay, thank you. And we will cover policy 4 a bit later on. Would the applicant like to say anything on this one?
No, thanks, sir. We can cover it later.
Okay, thank you very much. So we'll move on then to criterion E1, which is relating to impacts on communities and individual dwellings, including residential amenity, visual impact, noise, shadow flicker. So I would just like to hear parties' views on whether or how the proposal addresses that criterion. I did use the word compliance in the agenda as a shorthand, but I appreciate the policy wording talks about proposals demonstrating how impacts are addressed through project design and mitigation. So not necessarily reading that as a simple pass or fail. So can I start with the applicant on this criterion first, please?
Thank you, sir. I think the first thing to observe would be that it's not just a visual impact. There are other matters affecting community of communities, noise and shadow flicker. I think in terms of noise, shadow flicker, these are not issues in any contention here. In terms of visual impact, as set out in the LVIA and covered yesterday, there would be some significant visual effects from settlements. I think we have these recorded as Dalavik, 4.6 kilometres, in Berinnen, 5 kilometres. The assessment that this Oxley undertook in relation to these effects would be that they would be at such a distance and a level impact that they would not reach what we typically refer to in planning as the residential visual amenity threshold, where it may make a property so unattractive that it's in the public interest not to allow such conditions to exist, and therefore planning permission or Section 36 consent may be withheld to stop that type of effect arising. So we're not in that territory, but there are clearly some significance which have been acknowledged. I think the other point I would raise is that Ms Oxley referred to the design process for the project and a number of final principles that she sought to include within the final development, including the turbines evenly spaced, trying to avoid stacking as far as practicable. Although accepting clearly, if you yesterday, if you've got more than 2 turbines, inevitably you will get some crossover in some views of turbines. Design approach that would avoid almost the feeling of coming down the hill slope, setting back the turbines, and that all helps the perceived sense of separation between development, the development and that edge of Loch Howe. I think that's perhaps the acceptability, perhaps underlined by the lack of any objections from communities, critical instances, as we've touched on so far. So overall, the position would be that yes, there are some significant effects, but that's not unexpected for a development of this scale when NPF4 tells us that in this particular policy. The development we consider is acceptable with regard to those receptors. Thank you.
Okay, thank you. Can I invite the council to respond?
Yes, I think most of the comments been said by Mr. Bell, but also covered yesterday in the landscape hearing. Obviously, there is a matter to consider in terms of significance of impact on residences. Obviously, the applicant himself has outlined the significant major effects from viewpoints 1 and 2 and 4 and the like, which was discussed yesterday, which do have a number of homes that face on and over towards the wind farm. So as I would refer to yesterday's hearing on many of those points, and I don't intend to go into it much further.
Okay, thank you. That's fine. Happy not to repeat discussion that we've already had. Again, we touched on this point yesterday, the next point on the agenda, which is in relation to policy criterion E2 and how I should understand the term localised impacts and what implications that has in this case. Essentially, my understanding, the applicant considers the proposal's impacts would be localised, and the council is perhaps suggesting that they would not, due in part at least to cumulative impacts. I think just looking at notes from the discussion yesterday, the applicant touched on benchmarking with previous decisions in terms of distances and touched on the types of effects in terms of the extent to which any design changes would be perceived. The council was suggesting that really the nature of effects is also a relevant consideration, not just the extent, and there's also reference to previous decision. So I think I'd just like to explore that a bit further, and I will start with the council on this point, please.
Yes, yeah, obviously a lot of the matters were covered yesterday with regard to localised. My understanding is that there is no defined definition of what's considered localised impact. Obviously, the council's landscape consultant went into considerable detail on this and basically regarded the wind farm to be on more than a localised impact, given the location and nature and the viewpoints of the upper cragland. We also mentioned obviously decisions such as Fosside, which goes into matters regarding localised impact. Obviously, again, the council's landscape consultant discussed in some details cumulative impacts and considering the overall impact, which requires more than just looking at individual viewpoints. It kind of needs to be looked at in the whole and in the round. I think is pretty much what she was saying. So ultimately, I think she concluded that ultimately that part of this proposal has impact goes beyond what she considered to be localised. Thank you.
Okay, thank you. Can I invite the applicant for its views on this, please?
Thanks, sir. The first thing I would say is my understanding, having heard the evidence yesterday, is that the council's concerns, as set out in the objection, are to do with matters that would be localised in terms of the design changes that are sought. These would only be really perceptible on a localised basis. And the viewpoints that are in play on those concerns are well within the distance considered to be localised. The council has not raised a position in their objection on unacceptable impacts on a cumulative basis that are more than localised. So that's just some immediate observations I would make. I think Mr. Parsons fairly said, there isn't guidance on this. It may have been helpful to have had it at the outset with NPF4, but what we do have now is a series of decisions of the Scottish ministers where they have set out their view on what they consider to be localised impacts, supported by Nature Scot in most of the cases, based on the Nature Scot position. So I've set out 3 examples in my hearing statement from paragraph 4.6.26, a canny extension, which is one for 9.9 metres to tip, and then 2 others, perhaps of more relevance, where there are 200 metres to tip in Highland. And I don't want in any way to go into the particular facts and circumstances of those cases, but just to draw out that the ministers took the view that in both cases, with tip heights of 200 metres and distances of significant effects out 14.7 kilometres on Loyne, that the impact should be largely localised. And our position on this development is that the landscape visual of the development would be largely localised and should be treated as such for the application of NPF4 Policy 11. Now, I would add that I think it's important to acknowledge that the word generally acceptable in the policy does indicate that there may well be occasions where localised impacts may not be acceptable. We would fully accept that. I think there is one decision before the inquiry, which is the Glen-Dye decision in Aberdeenshire, CD 6.10, and it's inquiry report. I don't think we need to go to it, but just for your note, it's inquiry report, paragraph 9.132, where the reporters with that particular point about the full position of acceptability not necessarily applying. You may have a receptor that is impacted such that the scheme is unacceptable. So we would fully accept. I think when looking at the term localised, it's primarily the spatial extent. You need to establish what is the spatial extent by way of significant effects, and then, yes, look at the receptors that are affected. And what we do see as a pattern in decision is that where you have no significant effects on national designations, no significant effects on local designations, where you're not unacceptably affecting residential community amenity, or the position here with no objections, for example, and where you're satisfying all other matters, then that is the type of location where development is expected to go, and that comes through in the Scottish Minister's decisions. And so that's helpful. Thank you.
Okay, thank you. Is there anything in what's just been said that the council would like to come back on?
Nothing in particular, sir. Just passing reference. Obviously, it's kind of a subjective matter in many regards that we'll leave to you. Obviously, the landscape consultants, the council's landscape consultant, discussed this yesterday and gave her views on it, which we would sit behind. And obviously, within the council's report of handling, 7.24 sets out its position on policy 11E2. And again, just to be able to touch upon as well, but obviously looking towards the end of the related policy, it says where impacts are localised and or appropriate design mitigation has been applied. I suppose it's that part of the policy that comes into play as part of this overarching consideration, and which obviously in part the landscape consultant had issue with, as discussed yesterday. Okay.
Okay, thank you. So moving on to the next bullet points on the agenda, just wanted to touch on the benefits that are to be considered and weighed against other factors, and really just to clarify with the council whether it accepts that these are not only economic and community benefits as referenced in criterion C of the policy, but also a proposal's anticipated contribution to targets for renewable energy generation and reducing greenhouse gas emissions, which are referenced in criterion E, with the policy indicating significant weight is to be placed on the latter. And the reason I'm asking this question is really because there's a focus in the council's hearing statement on the former, so I just wanted to confirm its view on the latter. So I'll invite the council to go first, please.
Yeah, I think it's probably fair to say that we're in agreement that the proposal does have many economic and community benefits, as we previously alluded to, and we appreciate that there's significant weight applied to that, as indicated in page 54, I think it is, of NPF 4. So we would basically, agree with the sentiment. So.
Thank you. Does the applicant want to say anything on that?
Nothing further, sir. Thank you.
No. Okay, thank you. So we've probably covered this, but maybe just for completeness and just to be absolutely clear, just wanted the council to confirm its view on the balance of acceptability in terms of policy 11, and really is it saying that that's tipped by landscape impacts, visual impacts, or is it both? So can I invite the council just to clarify and confirm its position on that, please?
I think as discussed yesterday, I think the response is that to an element both, but primarily related to sort of visual impacts, where the balance has been tipped, as alluded to in council's landscapes officers presentation yesterday. Mr. Carr wants to add anything further to that.
No, I don't. I would also just defer to what Ms. Anderson said yesterday.
Okay, thank you. That's helpful. Does the applicant want to respond in any way to that, or can we move on?
Sure thing.
Okay, thank you very much. So that moves us on then to the next page on the agenda. So we're at point 3B, which is NPF 4 Policy 1 on tackling climate and nature crises. I'd just like to invite parties to give me their views on the implications in this case of giving significant weight to climate and nature crises. If I can invite the applicant to start on this one, please.
Thanks, sir. Starting point would be to acknowledge the proposal is national development, and therefore the benefits would be of national importance. And the implications of giving significant weight to both combating the climate crisis and the nature crisis would be that is a forceful consideration in applying the planning balance and when looking at the overall acceptability of the proposal. This is a project which also meets the obligations in NPF 4 Policy 3 in terms of providing significant biodiversity enhancement. But obviously, it also makes a nationally important contribution to the other limb of the policy in relation to the climate crisis. So we would say significant weight. And that's important for the striking of the balance, going back to what I was saying in the earlier comment about where you are in a location where you are not affecting designations and these matters are not in play. That has to be a matter that is of importance in striking the balance. Thank you.
Thank you. I invite the council for its comments on that, please.
Yeah, no, just broad agreement. I think from the council's perspective, there's clear recognition, responsibility, like the regions and countries to tackle the climate and nature crisis. I think a lot comes back to the balance of individual applications, and obviously that'll be for you to determine. So I think a lot is recognised with regard to the climate change, and then obviously with regard to nature crisis. Again, proposals such as this do help towards that. But obviously, again, we need to consider sort of the cumulative impact on nature of development, whether it be wind farm or any other development. And that needs to be considered in the round, and with regard to local biodiversity and whatnot. But largely in agreement with Mr. Bell's statement.
Okay, thank you. There's a particular point that I just wanted to discuss as well. The related point in the applicant's hearing statement at paragraph 4.5.8, that climate change is the greatest threat to biodiversity. Can I just invite the applicant briefly to explain that and what its view is on the implications of that, and then I'll ask the council whether it agrees or has any thoughts.
Thanks, sir. Yes, our position on that is that it's just drawing simply from government documents that clearly climate change is affecting climate habitat, and that has serious implications for extinction of species and around the world and biodiversity in the UK. Now, there is a document I appreciate. I thought it was lodged, but I found out this morning it's not lodged. But it was issued by the Scottish Government last year. It's called Climate Change, Scottish National Adaptation Plan. And it states within it that, and this is the Scottish Government's view, climate change is the biggest threat to Scotland's wildlife and habitats. And it goes on to talk about the impact on species and habitats and so on. So it may not be contentious to lodge that. I would recommend it goes before you, because it's the Scottish Minister's position on that, and that may be helpful to all parties. It should, as I say, should not be contentious. So I would say in this case are that there needs to be recognition of this issue, and how addressing climate change can help address that. And clearly we saw that just in policy one, but we looked at the wording there.
Okay, thank you. And ask the council for its views on the policy matter and also the question of the document.
If I could just jump in there, the policy document, no objection to that being lodged if that's what's desired by the applicant. One thing about the policy, which is stated in fairly brief terms, that there seems to be an elision then that has occurred. What I mean is this. It says, when considering all development proposals, significant weight will be given to the global climate and nature crises. So it's talking about two things, the global climate crisis and a nature crisis. And I think if I understand what's being said to you correctly, we seem to be then lumping them together, so that it's said by Mr. Bell, and it's in policy, that the climate change is the greatest threat to biodiversity, and that's a nature issue. But I wonder if that is the entirety of matters that are covered by the policy. Because if it was all just one and the same thing, then it doesn't make sense that it refers to two separate issues. Again, what I'm trying to get at this is that in terms of a nature crisis, we're looking at matters that are quite broad and separate from the acknowledged climate crisis. And that nature then encompasses other matters, such as the environment around and enjoyed by humans. and the world in which we live. And biodiversity is obviously an important matter to be taken into consideration there. And then you can see the crossover. But then there's also the separate matter with regard to the natural beauty, to use the wording from Schedule 9 of the countryside, or indeed of landscape and visual impacts, to use sort of the parlance that we had yesterday. So I wonder if we are in danger of conflating the two crises that are addressed by Policy 1, and if there is perhaps an intention of the part of the policy to consider the two separately, and therefore to place emphasis on the matters I've just described in relation to the second of those two, the nature crisis.
Okay, thank you. Would the applicant like to respond on what's been said?
Yes, sir. I think the policy intent in NPF4, you can read that. It's very short. It says to encourage, promote and facilitate development that addresses global climate emergency and the nature crisis. So there are two matters, but they are clearly integrated and interrelated in terms of how the policy intent seeks to address both of the issues. What I would not agree to is any position that this includes landscape impact and visual impact on people. I think we have clear division of policy within the development plan on the different receptors. I think this policy is entirely clear on a fair reading of it. There should be no ambiguity in my view.
I think the other thing that arises from policy is the fact that standing still won't cut it. It needs a positive response to the nature crisis. And historically, we've done a lot of information, people doing things and leaving that. So potentially, if you stop things happening, you'll be all right. And the reality is that, in fact, Policy 1 is a requirement to respond positively to the nature crisis, where humans intervene to try and alleviate the issues, and also to respond to the challenges that nature will be facing during climate change as well. So it's a twofold thing: trying to address climate change and then trying to look forward and say, well, what can we do against the nature crisis positively? And that then reflects in positive things happening to help nature crisis. So it's really a call to arms, I would suggest. And given the way in which it's put this policy selection is to all other policies, it is relevant to almost every aspect of planning that we do. And that's the reason. It's these larger things of we need to do something.
One final point I would add that may assist in NPF4. In the ministerial forward, paragraph 3, the very start, the minister states, putting the twin global climate and nature crises at the heart of our vision for a future Scotland will ensure the decisions we make today will be in the long-term interests of our country. Now, over the page is the spatial principles. And the second last paragraph under spatial principles is that national developments are the focus for delivery. So I think that ties the vision to the national spatial strategy to the delivery of national developments to deal with the two issues. Thank you.
Okay, thank you. Anything further from the council on this one before we move on?
Not from me, thank you.
No, okay. Thank you. I think it's 10:30. I suggest that we could push on through the agenda, see how we go, but I'm not sure if some of the other points may not take too long. We'll carry on for a bit if everyone's happy with that. And so we're on to policy 3, which is biodiversity. So I'd like to hear parties' views on whether the proposal complies with criterion B of the policy in respect of conserving, restoring and enhancing biodiversity, including provision of significant biodiversity enhancements. I understand from submissions before me that the applicant considers the proposal does this. I'm not 100% sure of the council's view on this. So can I perhaps start with the council, please?
Yeah, as far as I understand, the council are in broad agreement with that, with regard to item B. I guess my eye, just going back to the conversations yesterday, is drawn to policy D, with regard to sort of, again, minimising through careful planning and design element in terms of the impacts on biodiversity, but there's no specific comment with regard to biodiversity beyond that.
Okay, thank you. Does the applicant want to come in on this policy at all?
Nothing, sir, on that. Thank you.
Okay, thank you. So we'll move on to policy 4 then, which we did briefly touch on earlier. Policy 4 is natural places. So I understand council considers there's some conflict with this policy and the applicant considers the proposals in accordance with it. So to explore the reasons for that. Policy refers to protecting natural assets in policy intent and outcomes and to impact on the natural environment in criterion A, and it refers to nature conservation and landscape designations as well as to protected species and wild land. So I'd like to ask for views on scope of this policy, in particular whether it encompasses impacts on visual receptors as well as on landscape receptors. Can I ask for the council's view on that, please?
Yeah, I think this is more weighted on natural place impacts, but there is an overlap, I suppose, with regard to visual landscape impact, by the virtue of the type, location, and scale of wind turbines, as it were. But I think by and large, we don't have a huge amount to say on this, other than I think that it is weighted towards the impact on the natural environment, and we don't have an objection with regard to that. Obviously, we did reference back earlier with regard to cumulative impacts on landscapes that may need to be considered, but apart from that, no further comment.
Okay, thank you. And does the applicant want to comment on this one?
Yes, I think it's a very fair position of the council. I think we'd agree that clearly we'll wait on the landscape matters, but as on landscape designations, whether that's a national park or a local landscape area, they will have receptors within them, and therefore there is a visual element to that. And I think, as Ms. Hawksley said yesterday, landscape effects do need to be considered separately from visual effects. That's required by the GLPIA guidance, and also policy 11 that deals with the visual. So I think we're totally in agreement with policy 4.
Okay, thank you. That's helpful. So I'd like to turn now to policy 7, and got a couple of points on that one. Policy 7 relates to historic assets and places. We discussed quite a bit yesterday in the landscape and visual hearing about the proposal's visual impacts from Dún na Cúig, which is viewpoint 4. And policy 7 criterion I relates to nationally important gardens and design landscapes. And there's possibly just a small point, but in terms of the policy wording, I'd like to ask parties whether they consider the view from Dún na Cúig towards the application site represents an important view from the Inverary Castle garden and design landscape in terms of this policy. Can I invite the applicant to go first on this one, please?
Yes, I'm going to deal with this matter. The impact on the garden design landscape was assessed as part of the cultural heritage assessment. It assessed both the impact on the GDL as a whole but also specifically assessed the potential impact on the folly building itself, which is clearly the vision it's taken. So looking at context, looking at the actual asset here, it is designed, if you do that, to look down lot fine, and you'll look and see there is no visibility effectively towards the patient set at all. And it has been very clearly designed to look over down Loch Fyne and look over the castle. That's the orientation of the whole of the folly, and it's a design feature of it. So in the context of assessing the impact from this location, I think the impact assessment that was carried out in relation to that building is a very good proxy, because in considering that building, setting is obviously integrally related to the wider GDL because it's part of it. So therefore, when you're assessing the setting and the cultural heritage chapter, that relationship between this particular location and the wider GDL is the fundamental issue. Clearly, the views are fundamental to that. In that context, the environmental statement found that there would be a minor impact on setting in relation to the folly. And in relation to that particular aspect, Historical Environment Scotland, in their consultation response, which is CD 1.215, also in the appendix to that letter, they carry out an assessment of the assets that they consider worthy of consideration. And on the last page, they deal with Dundee and Cook, and they expressly state they agree with the applicant's position and assessment. It would be a minor effect on setting. You put all those together, in my view, there's a very clear finding that the site does not sit within view, it's to, from, or within the site where it's sitting that's important. And I think that's findings of the cultural heritage and agreed with the relevant consultee. That's where you'll find our position. It really add much further to it. So I think it's very clear when you go there, you'd have experienced it. I think even runs accepted in visual terms, equally it wasn't as sensitive as most important piece. I think we have broad consensus on that in the evidence. And it's also about assessment, which is really thought about those relationships. Some more detail.
Okay, thank you. Can I invite the council to respond to that?
Yeah, I think my understanding from listening in to yesterday that consultant did have quite a significant concern with regard to the viewpoint from Donaghadee, viewpoint 4, I believe, and on its impact. I think she discussed about 360 views of the GDL. She discussed from memory that its forms within the GDL, and she acknowledged, I think, that yes, it is at a higher level, but it does have that 360 panoramic view and does look down onto the lowlands, as it were. So from that point, my understanding and my recollection of it was that she considered that it was potentially an important viewpoint from that regard. As I say, we're not going to go into any other matters because it's not related to the council's matter, but Historic Environment Scotland, I think I've commented on this matter, and I'll obviously point you towards their consultation on that.
If I could just chime in as well. Policy 7, historic assets, and that criterion. The question that you've posed, sir, is whether or not it's an important view from the GDL, and the short answer is no.
Okay, thank you. That's helpful. So we'll move on. The next point that I have under policy 7 is in relation to impacts on Fincarn and Ardconnell Castle, referenced in the Council's hearing statements, and there's a reference to concerns about policy criterion O. On reading the policy, it appears to me that relates to non-designated assets, and I understand that both of those assets are scheduled monuments, so I just wanted to confirm whether criterion H might be the more relevant policy criterion. Can I just ask the Council for its view on that, please?
Yes, sir, I would agree with that interpretation. Yeah.
Thank you. Any comment from the applicant?
Well, given that the matter has been raised, I do feel I have to respond, do so briefly. Just in terms of Fincarn Castle is beyond 10 kilometres from the turbines. As a consequence, at the time of scoping out the assessment, consideration was given to having a 10-kilometre study area. Now, the consultants considered density with this area, and so did HES. In CD 1.12, which is the cultural heritage chapter, page 12, there's a response from HES, which is reporting there was an agreement to a 10-kilometre, particularly a 10-kilometre to study area, having given consideration to whether there were any assets in 10 kilometres would give rise to concerns regarding setting. So that's how that's not referenced in the cultural heritage chapter, because there was agreement in relation to that. Mr. Ferguson's hearing statement does go on to reference this, and I think there is two matters I want to just pick up. One is that within policy H, the threshold is integrity of the setting. There is the policy threshold. And again, as their consultation response are very clear that while there is have desires to have turbines reduced in height, they did not think the current patient as proposed will first, and this required an objection in national interest. I think that is also relevant to this. And I think this is probably quite helpful matter for a number of matters. Is that having raised this matter, I did think it was perhaps appropriate to at least have the context of the Blair-Gower decision making. That is document CD 613. And the killer paragraphs dealing with heritage, and in particular scheduled monument, starts at paragraph 71 on page number 11. In relation to the monuments that we've been talking about, I've got paragraph 73 lists from Castle scheduled monuments. And then in paragraph 74, there's a statement that as advice is that the effects of the scheduled monuments set out could be mitigated by either deleting, relocating, or reducing the height of a number of wind turbines associated with the proposed area development. And then list 5 turbines, which then issues with. We then get the Scottish Minister's determination of this issue. And in there, they note that the requirement for solar turbines proposed very development would substantially increase the average energy production, making a greater contribution to achieving net zero targets and provide a wider choice of turbine options, thus improving the commercial viability of the project and route to market through increased energy yield. Now, you'll recall that the turbine heights proposed here are exactly the same as those that used at back out 180. And another key passage here, which I think is very interesting for one of the issues that we've been discussing throughout the last couple of days, is the Scottish Minister's state that at 76, the Scottish ministers are satisfied that the proposed dairy development has undergone a thorough design iteration process, which took account of all the environmental constraints, and the current location of the wind turbines is significant to landscape visuality and habitat sensitivities. And there's two things that really flow from that, which is when the Scottish ministers are faced with a challenge about design, they are putting it in context of saying we need to look at it in a design process, and that you can't just look at every individual issue in isolation in terms of design. And I think it is a relevant factor to get back into, because this is actually at heart of some of the issues we have before us at the moment. You can fact policy 11 and the energy policy, the various E, the policy states is in addition project design and mitigation. So the outset of E is all about project design and mitigation. Will demonstrate how the following impacts are addressed. Now, the way in which that is formulated does not suggest that you just take one in isolation. These are factors project design should take into account. And as we've seen from the minister's decision making by Gower, what they want to see is the process. And there will be a balance of various factors. So that was a useful illustration in the context of something sure it's obviously directly relevant in the sense of we're dealing with similar turbines, similar landscape with similar issue. And therefore, this particular decision does have a very direct bearing, and the approach there is, I suggest, very clear.
Thank you. Would the council like to come back on anything that's been said just now?
I'm just a bit perplexed as to how that relates to the question about Finchurn Castle and Ardconnell Castle, but I think that was all very helpful exposition of the applicant's position, but I have nothing to add in relation to that topic area.
Yeah, I would agree. We rest on the HES consultation.
Thank you. In terms of the agenda and MPF 4, I've got a sort of wrap-up point to bring out any other policy matters that people want to raise. Just, I'm wondering if I might have actually just skipped over one of the bullets under policy 11 earlier, because I'm not sure if I actually invited views on the point about appropriate design mitigation. Correct me if I'm wrong, but I think I may have skipped over that one.
Yes, you did indeed skip
yeah.
that, but I thought you'd done that deliberately along with the prior bullet point with regard to cumulative impact, because I thought you'd taken the view that we discussed all of that all together in our answers generally.
No, it wasn't intentional, but I mean, equally, I don't want to repeat discussion from yesterday. But I am happy if there are any points. Obviously, yesterday's discussion was specifically around landscape and visual, and now we're looking at how that ought to be interpreted in policy terms. So perhaps we can just return to that bullet and the one above, and I'll just invite any comments that parties do want to make. I mean, I think the discussion yesterday, in summary, the applicant considers that appropriate design mitigation has been applied, and that's demonstrated in the design and access statement, and the council considers that that's not gone far enough, with a particular concern about viewpoint 4, among others. So I don't want to repeat all that, but I would just like to return to those bullets because I didn't intend to skip over them. So if there are any points, that one and the one above, about localised and cumulative, so if there's any points, I'll perhaps just start with the council on that, if there's anything that you want to add beyond what was said yesterday.
I think as far as the council's concerned, I don't think I could gainsay or place things any better than Carol Anderson did yesterday with regard to those matters. She gave her views on mitigation. That feeds into policy. She gave her views on the question of localised or not. She gave her evidence with regard to the cumulative impacts as she decided upon in her applying her particular expertise on that. And these matters will tie in as well, not only to policy, but also in terms of the legal test under Schedule 9. And I've already addressed you on all of those, and Carol Anderson has addressed you on the evidence of those. So I have nothing further to add. Thank you.
Okay, thank you. Does the applicant want to add anything on those points?
I think I commented earlier today about the design steps in relation to a couple of the agenda items referring to Ms Oxley's evidence. So I don't think I have anything to add on that. And in terms of cumulative impact, we've touched on sort of our position at the start was highlighting that isn't the matter that's in the council's objection in terms of unacceptable cumulative effects of the scheme.
I think the only other to add is to say that point the Scottish ministers have already illustrated decision making. Policy E is about a project design and mitigation having regard to a series of factors. Clearly there's an expectation that in terms of this landscape visual matters, design will apply. Now, I think I'm not going to repeat that yesterday. She described her role in the design and access process, which led with landscape visual matters, and then further constraints were led in at each stage as to what could be achieved. So they were at the forefront of the design process, and that was her. And I don't think we need to let other states to know that and better exactly what your is.
Okay, thank you. That's helpful. And my apologies for skipping over those as we went through earlier on. So just to close the NPF4 discussion then, 3F on the agenda is really just to invite parties to raise any other policy matters. Having reviewed the other parties' hearing statements, I don't have any specific questions on any other policies. But can I start with the council, please, just if there's anything to raise?
Nothing to raise.
Okay, thank you. And from the applicant?
Anything on this agenda item, so thanks.
Okay, thank you. There's a couple more items on the agenda. It's perhaps worth just taking soundings on whether parties think they have much that they're going to want to say on those, or if not, we can perhaps push on to the end. Have any views on that?
For the applicant, we would suggest a 10-minute break. There is a bit of matter we do wish to respond to under any other relevant matters. But there are a range of matters raised in Mr. Ferguson's statement, which this is the only chance we have to respond. But as brief as possible, we might extend into the period where on screen it becomes tired or whatever. So
that's fine. I'm happy to take a break. So that's fine. We'll do that now, and we'll return at 11:05. Thank you. Sorry, Mr. O'Carroll, were you?
I was just wondering that we had a 15-minute break at this point yesterday. I wonder if you could extend it to that to 10
Yes,
past.
yeah, I'm happy to make it 10 past. Thank
Thank
you.
you very much. I appreciate that.
We left off just before coming on to item 4 on the agenda, which is the local development plan and associated guidance. In terms of the Argyll and Bute LDP, again, as with the last item before we had break, I don't propose to go through policies in detail, but I would invite parties to raise any specific points. There was a mention earlier of policy 02, so we can pick up that point. In broad terms, I understand that the applicant considers the proposal accords with relevant LDP policies, including policy 30, the sustainable growth of renewables. That's set out at the applicant's hearing statement, paragraph 5.4.2, and also in the statement of agreed matters at paragraph 9.3. And I take it from the council's hearing statement that it considers there to be some conflict for similar reasons to those that we've discussed in relation to NPF4, in particular in relation to landscape and visual impacts. So I'd just really like to invite parties to confirm if I've understood their positions correctly, and if there are any particular aspects or policies that they want to highlight just now. I'll invite the applicant to lead off, please.
Thanks, sir. I think that's really nothing really to add. I think topics that might be raised by the policies we've already aired this morning and yesterday. So nothing further to add. Thanks.
Okay, and the council, please.
Yeah, I would agree with Mr. Bell as well, and your summary, sir.
Okay, that was nice and quick. Thank you. We'll move on then to 4B, which is the Argyll and Bute Landscape Wind Energy Capacity Study, which we discussed yesterday in the landscape and visual hearing in terms of which elements of it are relevant in this case. So I don't want to repeat that discussion, and I've noted the council's view expressed yesterday that it was outdated in relation to turbine size. I would just like to ask today for views on the weight that should be attached to that document in the context of yesterday's discussion about which sections of it are of relevance and which are no longer in accord with national guidance. So can I invite the council, please, to lead on this one?
Yeah, I think it was acknowledged yesterday, and I think it will probably just rely on that, sir, in terms of comments made by the landscape consultant. I think it was acknowledged with regard to the age of the document, but it was still nonetheless seen as a relevant guidance document. And I think both parties agreed that it is that a form of guidance document that helps inform wind turbines within Argyll and Bute. It makes specific comments within the executive summary with regard to how they went about the analysis, which perhaps hasn't changed again, albeit it is acknowledged that there are larger wind turbines in the area. So I've got much further to add to that, and I would rely on the landscape consultant from the council yesterday's hearing. Thanks.
Okay, thank you. Did you want to come in, Mr. O'Carroll? You're on mute just now.
If I can just add to that, agree. Simply, I think matters were covered entirely by Ms. Anderson yesterday, but what you're looking for is the question of how that feeds into policy and the way to be applied to LWEX. That in turn is informed by the evidence that was led. So in terms of the landscape character types, of course, are matters that are unchanging, and the matters that have been adopted by both parties in their analysis of the impacts, landscape and visual, especially visual. And the question of relative sensitivity, the relative sensitivity of certain parts of the Argyll Peninsula still remain to be the case. The question then is the weight to be applied to it in light of its shortcomings in terms of the date of it and the change in planning policy in the meantime is the issue that I think you're driving at. And again, drawing upon the evidence of Ms. Anderson yesterday, I would submit on behalf of the council that it is still a document to be accorded significant weight. And I say that for the following reasons: that notwithstanding its age and the fact that it predates more policy and indeed Nature Scout guidance and of course NPF and WPS, in the meantime, it still relates to matters which are immutable. And the matters that are immutable and have not changed is the nature of the landscape. The landscape has changed in this area within the radius, the relevant radius of this particular development in relation to two built developments and a number of other consented developments. And obviously the landscape has been considered in those contexts. But all through the time at which all other proposals have been considered in this part of Scotland, LWEX has universally, uniformly, and consistently been recognised as being a relevant document, which is of assistance in decision making. Well, it's of assistance, first off, in terms of being a guide as to areas to be avoided and areas that are preferable for the location of wind turbines of whatever height. And that is acknowledged by Sam Oxley in her evidence yesterday, because she said that she made reference to certain parts of the landscape that were deliberately avoided, she said, and parts that were deemed to be more acceptable in visual terms. So I think it's an acceptance from, certainly even from the developers themselves, that it is a relevant document that is useful. And in terms of the weight that should be applied to it, given the immutable part of the countryside that doesn't actually change, and only the question of relativity, it still remains the same nonetheless. It is still a document that I think should be accorded significant weight in consideration of your recommendation to ministers. That's what I would submit to you, sir.
Okay, thank you. Can I invite the applicant to respond to that?
We took a very different position to the one by Mr. Carroll. Firstly, from a planning perspective, I would say I've never seen in a decision on an onshore wind farm significant weight be afforded to a study of such age, and one that is contrary to Nature Scout guidance, 2022 guidance, which is CD 4.12. Also, the document was not given significant weight in the Clackaig Glen decision, which is CD 6.7, that's the inquiry report. And I referenced that yesterday by saying that the conclusion of the report that there's no possibility of turbines over 150 metres being accommodated within our Argyll Butes, clearly a judgment that is wrong in today's context, as evidenced by the various decisions of tip height consented schemes well over that rate. Then there's the 6 factors that the reporter in Clackaig Glen highlighted that now are different in today's context. So we would agree that there are elements of the document that are informative, and that is accepted. We disagree on the matter of weight, and our position would be only limited weight. So we reckon is material, but only limited with those provisions, and more weight be placed upon a site-specific LVIA that deals with the detail of the project. Thank you.
Okay, thank you. Is there anything further from the council on that before we move on?
Thank you, sir.
Okay, thank you. So that takes us to item 5, which is any other relevant matters. And the one matter I have noted on the agenda here is to give parties the opportunity to explain the relevance, in this case, of previous decisions referred to in their hearing statements. Obviously, some of these have already been discussed as we've gone through earlier agenda items. So I just wanted to give an opportunity here for anything that we've not already touched on the parties want to highlight to me as being relevant in this case. And then after that, I'll give the opportunity for any other matters that parties want to raise before we close this session. So I'll start with the applicant in this case, please.
Thank you, sir. Wanted just to respond to what Mr. Ferguson sets out in terms of previous decisions. This is his hearing statement on page 18. I was going to comment on two, there's usually three decisions to bring in. One is Fawside, and then Personican. Both are section 36 cases. I was involved in both of these, so I know them quite well. Now, Fawside is by Mr. Ferguson on page 18. It's CD 6.19 and 20. And it's a fairly lengthy bit of text, Mr. Ferguson's statement. Now, there's two important things that are not brought out on that decision, Mr. Ferguson. One is that in the inquiry report, I don't think we need to go there. I forgot I can give you the paragraph references, but happy to go there if you need to. In the inquiry report at paragraph 9.17, the reporter identified that there would be significant adverse effects on the special qualities of the Langham Hills regional scenic area. So that's significant impacts on a local landscape designation. That's not brought out in the, but I think more importantly, paragraph 920 of the inquiry report, the reporter identified that there would be unacceptable visual impacts on residential properties. Again, that isn't brought out. The conclusion that Mr. Ferguson draws at 5.14 of his hearing statement is that states the decision of the reporter is largely informed by landscape, visual and residential amenity impacts. It is considered that the case is relevant as the two areas are similar with long-range landscape views extending for some distance. Now, in this case, we've established, I think, and reached agreement that the effects are largely localised. There's not long-range landscape views in issue in this project, i.e. Carr Dubh. And one of the key points in Fawside is if unacceptable for identified on residential amenity, and for me that would be it. The scheme should be refused. You cannot outweigh an unacceptable impact with benefits. So I don't think Fawside is particularly helpful. There may be some points, to be fair to Mr. Ferguson, about the localised impacts. I would certainly accept that, the way that is perhaps explored. But beyond that, I don't see the particular relevance of Fawside. Just going on to Personican, which follows in the hearing statement again, I think there are three points that are not brought to your attention there. Firstly, the Personican project, there was an objection from Nature Scott. Now, Ms. Anderson said yesterday, reasonably clearly, that Nature Scott's not that often. It's typically if you've got a national park or an NSA issue, but they can also object on a national interest point where they consider a regionally important landscape is affected so much that it raises a national interest matter, and they bring that to the attention of the ministers through an objection. Now, in Upper Sonican, they did that in relation to the impacts on the north end of Loch, which is more sensitive. It's got the tourist route to open, and they in particular raised the national interest issue on the impacts and how they would relate to the use of Brander, which is when you're travelling westwards below Bentruchen, you go through the place of Brander. So Sonican had these particular issues in play. Now, Mr. Ferguson, in paragraph 5.16, states at the end, and he quotes, and effects on a landscape that contributes to Scotland's national identity, brackets, namely Loch. Now, I think his inference there is that you should take into account that Loch Awe is a contribution to Scotland's national identity, such that the impact on it is unacceptable here. Now, that code relates to the national identity point in Nature Scots objection, primarily concerns the north end of Loch Awe. It doesn't concern the southern end that we are dealing with in this case. So I think if you were to look at these decisions, then it's important to bear in mind those points. The other scheme that's referred to is Killearn 2019. I don't really know that scheme very well, but given its date, it's pre-NPF4 policy, so I'm not sure to what extent that is helpful. Before we cover Ladyfield, I think Mr. Innes could cover Errigal and Darkin, but I'm happy to pause at that point. I've talked for quite a bit. If you want to give the council an opportunity maybe to respond, then we can cover the other two cases.
Yes, happy to do that. Would the council like to respond at this point, please?
No, I think there's a lot in that. I agree with Mr. Bell that obviously decisions need to be considered in the whole or in the round. So I acknowledge that. I think obviously these are sort of snapshots just to provide overviews. And obviously with regard to the Forsyth decision, it relates to localised impacts. That's out in 5.13. And I think there was an agreement. Mr. Carr might correct me if I'm wrong yesterday in terms of on this proposal being specifically only localised in terms of its impact. So there was discussions that there was much broader impacts that were created by the proposal and well beyond sort of localised impact. So obviously this decision comes into play and the commentary that is provided with you on that. With regard to Upper Sullivan, again, we understand that you have to take decisions on the whole, sir, but ultimately, again, it was just pointing back to the relevance in terms of consideration of landscape and visual impacts as outlined in paragraph 5.16, that we think is required to be taken into consideration, and perhaps the impacts of certain parts of the proposal, not all of it, certain parts of this proposal have larger impacts than has been alluded to by the developer. So I'd say many of these cases are in passing, but those are the key points.
Mr. Ferguson asked if I was correct and if I was wrong. I'm afraid I didn't quite pick up the comment, but if I could just summarise what I think I heard and just ask for confirmation. I think you were saying that it wasn't agreed yesterday that impacts were localised only.
Yeah, well, that was, I was trying to get understanding. Obviously, I wasn't a party to the hearings. I did.
Well, if that was your understanding, that would be correct. It's not agreed. Yeah. It's not agreed. Being clear from Ms. Anderson's evidence, not agreed either individually or, more importantly, cumulatively speaking.
Yes.
That the impacts are merely localised as the applicants would state.
Yeah, that was my understanding as well. Thanks for clarifying that.
Okay, I'll bring the applicant back in either to respond to that or if there were other points I think you indicated you wanted to move on to as well.
I think I'll rest on the evidence that was covered yesterday, sir, on localised. That's fine. I think Mr. This is now going to cover the other two cases, and I'll refer to Ladyfield. Please.
Yes. So I'm going to deal with Gale first, which is 6.23, which was a scheme located at the far north end of the entire peninsula. It is a relatively recent decision and taken in context of for policy. I'm just going to a couple of very brief points and then go to the decision making. In terms of paragraph 76 of the report, there's clear findings from the reporters regarding impacts on the North Arran National Scenic Area. And insofar as the findings were, it was to have significant adverse effects on the spatial qualities of the national scenic area. In addition, paragraph 77 of the same Scottish ministers agree with the report's findings in relation to certain more localised impacts within Argyll and Bute, including a substantial impact on key landscape features that are likely to have contributed to the South Cowles designation. Now, in that stage, I think it was called an APQ, an area of primary quality was the designation. Terminology changes, but I think the designation largely remain the same. But that's a local landscape designation. So we've got obviously localised significant effects. We have wider significant effects on both a local landscape designation and the national scenic area. In terms of decision making and conclusions, paragraph 142 is quite helpful in that, insofar as the decision making is concerned, there's a finding of failure to comply with policy 11E2 on grounds of the impacts not being localised, and those effects are the ones that were found in the North Arran National Scenic Area. And then the key finding in policy terms was a failure to comply with NPF 4 policy 4C1. It's effectively the policy that you get referred out of policy 11 when you're affecting a national designation. So you see that interrelationship between 11 and 4 coming in. And the overall decision making is conducted in 150. And again, I think the only real point that you can take to that is that even where you have failure to comply with policy 11, or indeed policy 4.1, there's a balancing exercise that has to be done in the overall decision making. And ultimately, the Scottish ministers in that case found the balance of the benefits did not outweigh those effects. And as far as the relevance to the decision making here, there is no national scenic area effects, and nor is there in this case an adverse effect on any local landscape area, which would approach the level identified in no significant effects. But what's interesting, the overall balance, negative, it's the North Arran NSA that's thrown into the balance, not the impact on the local landscape area. So in my submission, it's doubtful that there's anything of real relevance within this particular case that bears and comes to be considered in current circumstances. The second case I was going to deal with is 624, which is Iraq. It's an even more narrowly focused refusal in terms of again, it's entirely focused in relation to the impact on the national scenic area, the same one, the North Arran one, by virtue of aviation light. One further to apply with NPF policy 4C1. And the concept of it going beyond localised, again, this scheme is with northern parts of the Qatar Peninsula, and it's extending into the west of the North Arran. So again, it's a decision again which doesn't really have, in policy terms, any bearing or direct relevance to the matters which you have to determine.
Okay, thank you for that. Would the council like to respond to anything that's been said on those particular decisions, or indeed any others that you'd like to bring out?
Not really, sir. Argyll's has been covered, and we rest on those comments. The Arran one was with regard to maximising socio-economic benefits and socio-economic effects, which I think we covered earlier on in the hearing session.
Is there anything else in relation to other decisions that either party wants to raise before I invite any other matters to be raised? Yes, the applicant.
Thanks, sir. Just briefly on Ladyfield, to give you some observations on that we think are relevant to this case. So Arlyle is clearly a scheme within the locality. At paragraph 23 of the decision, the planning authority did not object. Now that's almost the same as here. We clearly have a position where the planning officers were content subject to the design points. The planning authority clearly objects to what we're dealing with today. Paragraph 25, it states that although there's no objection on landscape, as far as planning authority considers the scope to reduce effects on particular views, including doing the quick, by substantially reducing the height of turbines 11, 13, or by removing them. And then the ministers go on to deal with this at paragraph 75 and 78. And at 78, the ministers, it states that the ministers acknowledge that development will have some significant landscape impacts. They would remain relatively localised. And they state, in weighing up the benefits of removing or substantially reducing height of turbines, ministers have reached a view that the impacts would not lessen to a degree that would warrant the reduction in electricity production. It is also acknowledged that no national or regional landscape designations will be significant. It's therefore considered by ministers the landscape and visual impacts acceptable. Now, in terms of similar points, we don't have national or regional landscape designations. We have the relatively localised impacts. Maybe some disagreement with the council, you've got the positions on that. It seems very similar to the position in the Blairgower case that Mr. Innes outlined earlier. And I think the important point is this. I think in the evidence yesterday, in talking about the changes that could potentially be made to turbine, Sanderson said it's a matter of economics. And I would take issue with that. And I appreciate Ms. Anderson's not a planner, and she wasn't speaking in really a policy context, so I don't criticize her for that. But the benefits, as we talked about earlier, are all about public benefits and about installed capacity and energy output to meet the climate emergency and the statement of need that we set out at the start of the day. So we would say that there is a need for that urgent deployment. That's clearly a matter to be weighed in the balance, that if this is a national development benefits, are the adverse impacts that would result so unacceptable it has to be refused. And clearly the energy reduction, which Mr. Valens outlined, about 40% per turbine, it is a material point to be put into that balance, which clearly, as Mr. Ferguson said, you will be recommending on, and then the minister will be deciding. So I just wanted to highlight that from a policy perspective and how to weigh in benefits. That and Blairgower, the way that has been approached, I think is quite helpful. Thank you.
Okay, thank you. Just as we've gone through and I'm looking at the core documents list, can I just confirm core document 623 was quoted in relation to Errigal, which I think is the decision letter. I'm not sure if Mr. Innes, you were quoting from the report, because if so, I'm not sure that the report has been lodged.
So what I was reporting is that this is quoted what the reporters had said, and at the end of it said, I agree with them. So that's fine.
That's taken from the decision letter.
Letter, so yes.
Yeah. Okay, that's fine. And Just checking if I actually have the Ladyfield decision.
Sorry,
Before me.
631.
Yeah, okay, that's fine. Just checking the reference for that. Okay, thank you. Are there any other matters in relation to these decisions, or any others either party wants to raise?
So I don't have anything more on the leading field. Just just mention or come back on that slightly. Obviously, everything's considered on its individual merits. There is obviously a conflict in opinion in terms of localised application between the parties, but often the council, Mr. Bell is right, do not object to it, but the critical thing is it's subject to mitigation, and they have done that with many developers in the past, and obviously the way weight to be given to the employment and energy production, we will leave with you as well. I think the council would say that obviously the slight reduction through the mitigation proposed would still provide those benefits.
Just to say, in terms of the option in turbines, we have been very clear and put in evidence that there would be a material difference in benefits. We provided figures on that. So that is a matter to be afforded weight when we're considering national development and the climate emergency. And the onshore wind statement uses the term onshore wind is mission critical to targets. Now that's very strong language, and we think clearly has to be taken into account, and considering what the reduction in benefits would be from the changes that the council contend are necessary. Thank you.
Okay, thank you. So just staying with item 5, are there any other matters that we haven't touched on earlier on in the agenda that parties wish to raise in terms of any energy or planning policy matters?
Not from us. So
anything from the applicants?
So yes, I just have one matter in relation to what's said by Mr. Ferguson just there about viability. Currently, the route to market for onshore wind is one TFD process. That is a competitive bid process where, for example, Scottish onshore wind needs to compete with solar from elsewhere. And so when we see references in black out to the deliverability, it's very clear the Scottish ministers are also in regard to will these be delivered and can they be competitive? It is a dynamic process. So when we're considering granting consent, that viability issue can't be just determined now. It will be at a future date in a competitive auction. And so when you see comments from the Scottish ministers, such as that of Bagower, they have understood the very strong relationship there is with taller turbines and the ability to be price competitive in that market. That's reflected in the onshore wind policy statement, which in itself talks a lot about deliverability and the ability of onshore wind to be delivered. So it's just to put that point in context. So when we're talking about onshore wind, it does have to compete with other technologies elsewhere to be price competitive if it's to be delivered and thereby meet Scottish Government's objectives. I think it's important just to note the context, because that's really what the Scottish ministers were alluding to in the Blackdown decision about this deliverability. As I think they had yesterday, in the tip height by 30 metres, on a site like this, drops the annual yield from the turbine by 40%. So 40%. So that's the scale of the magnitude of the reduction in competitiveness as far as the technology is concerned. That is reflected in the onshore wind policy statement with the underlined reference that Mr. Howe made further on. So seeing that was a necessity for the taller turbines and efficiency to enable deliverability. So it was just I wanted to put that in proper context, not just just a percentage reduction.
Okay, does the council want to respond on
Yes,
that?
I don't want to engage in ping pong, but I forgive me if I've missed this, but I wonder if there is a document before the inquiry that vouches this 40% reduction when you have a 50-metre reduction in turbine height in terms of productivity from the turbine in question.
I'm perfectly comfortable to respond to that. It was given in evidence yesterday, and Mr. O'Carroll, it was in relation to specifics of this site, because we now currently have asked on site, and as Mr. Vance said, he had asked to understand what the percentage of the reductions in annual energy production would be if we got the tip point. So it came directly from the. Insofar as these measures considered, this is clearly a matter that relates to design, and we've put it in evidence. And Mr. O'Carroll will be very clear that in the environmental impact assessment regulations, the party who is seeking a percent in terms of the regulations put forward either wrong or misleading information, it's a criminal offence. So I think you can say that the applicant in this situation is not likely to just pull figures out of the air to think
of course, Mr. Innes, of course, sir. I wasn't alleging any criminal offence being committed or impugning the integrity of the witnesses. Please don't take it to be that way. I was just wondering if there were some figures we could look at as opposed to the live evidence we heard yesterday. That was all.
My recollection from yesterday, there's a couple of particular examples referred to and particular figures on those, but I don't think there is anything written in relation to that at present.
It matters because I think in responding to Pez, we did provide specific figures about the energy yield production that would be lost in their suggestions. There was a process of Pez lodged a representation looking to have turbines reduced, etc. And there was in that response, I think, responding to those. I think for the purposes of what we're dealing with, I'm at the range in terms of what we're talking about, 58 to 40%, is about what a site is about as good as you get. And if we want specifics, and more likely to probably do it, we will give the indications of what the likely yield reduction will be, and it will be slightly different for each tower, but it's not going to be a vast difference. What would happen if you do it?
And I don't have a strong view on needing specifics. I understand the general point that was being made, and I'm happy to hear any other comments that the council wants to make on that.
Sir, that was just a question from me. Ultimately, the matter is entirely for you. If you would like that further information, then no doubt you will ask for it. But if you don't, then
Yes,
it's out of my hands, so clearly.
that's fine. I'll certainly reflect on matters, and if I do decide that that would be helpful, then I'll request that in writing subsequently. So, any other matters before we move on, just to close today's session?
No, thank you.
Nothing else, thank you.
Nothing else.
Okay. In that case, that brings this policy hearing to an end, and I'll close the session now. I think the matter just to discuss and agree before we end the call is arrangements for the next session. We had discussed yesterday that rather than having that at 2 o'clock, we might be able to bring it forward. It's now 10 to 12. So one option might be to bring it forward to 1 o'clock, but that's dependent on the availability of the relevant participants. So can I just invite any views on what time might be suitable?
I've got both of my witnesses on tenterhooks ready to pounce and to give evidence at the drop of a hat. And so I think 12 o'clock might be a little bit sudden, but
So 1 o'clock.
I think I say it would be theoretically possible for them to appear at 12 o'clock noon, but I think 1 o'clock might be perhaps interrupt lunchtime, but that's a matter for you. But
yeah,
I would suggest 12:15, and then we could break it at 1, but that's a matter for you. But certainly I think 12:15, as far as the council's concerned, would be possible.
if we can just take a relatively short break now rather than taking a sort of early lunch, if parties are sort of primed and ready to join us. Does the applicant have a view on that?
We're very relaxed. We're here, so we can respond to whatever you want. And I think we're just on with it is probably the answer.
That's fine then. Okay, well, in that case, I'm happy to run with the suggestion of 12:15, just to give parties time to make sure everybody's available and dial into the call and so on. So we'll see everyone back who's participating this afternoon at 12:15.
Excellent. Thank you, sir.
Thank you.
Thank you.
Okay, good afternoon, everyone. It's 12:15 on Thursday, the 29th of May, and time to begin this hearing session. This hearing session forms part of the public inquiry into the application by Carr Dubh Wind Farm Limited for the proposed Carr Dubh Wind Farm under Section 36 of the Electricity Act 1989 and Section 57(2) of the Town and Country Planning Scotland Act 1997. My name is Philip McLean and I'm a reporter with the Scottish Government's Planning and Environmental Appeals Division, or DPEA. I will report to Scottish Ministers with my recommendation on whether the application should be approved or not. The topic for this afternoon's hearing session is draft conditions. The main purpose of the session and of all the sessions in this inquiry process is to make sure that I understand the positions of each participant on the topic in question. In this instance, the conditions that should be attached in the event Scottish Ministers approve the application. Where there's disputes, I need to be clear on the reasons for that dispute so I can properly set these out in my report to Scottish Ministers. For the avoidance of doubt, and in particular for the benefit of any parties watching the webcast, this discussion on conditions is without prejudice to my eventual recommendation or Minister's ultimate decision on the application, and none of the discussion this afternoon is to be taken as implying overall support for the proposal from the Council. A few initial housekeeping matters to run through. This meeting is being recorded and broadcast live, and Stephanie Tinto from our IT team will be remaining on hand in case of any technical difficulties. In due course, the recording will be available to view on our website. In accepting the invitation to this meeting, you have agreed to being recorded and to the use and storage of images and sound recordings and any information contained in them for webcasting and training purposes and for the purpose of keeping historical records and making those records available to the public. For data protection and privacy reasons, we request that participants or observers do not take any photographs or other recordings of their own during the session. Please mute your microphone when you're not speaking and raise your hand or wave if you want to attract my attention or contribute at any time, and please ensure mobile phones are on silent. I'm physically located in the DPA office in Falkirk, not expecting any fire alarm tests this afternoon. As there are participants here this afternoon who were not involved in earlier hearing sessions, and I now invite each of this afternoon's participants to introduce themselves and their teams, starting with the applicant, please.
Good afternoon, sir. My name is Colin Innes. I'm a partner in the law firm of Sheffield Wedderburn. I'm appearing on behalf of the applicant in relation to the conditions section. I'm accompanied by Scott Balance of Statcraft. I will be doing the block speaking. Thank you, sir.
Okay, thank you. And the council?
Good afternoon, sir. Maurice O'Carroll, member of the Faculty of Advocates, advocate for Argyll and Bute Council in this case. I'm accompanied today by Arlene Knox, who is a planner within Argyll and Bute Council, and also Richard Perkins, who is an independent acoustics expert who will be discussing amplitude modulation suggested condition today.
Okay, thank you very much. I made a number of remarks when I opened the inquiry yesterday, and I don't intend to repeat all of those in full, safe to say that they still apply. But as we do have participants in this hearing who were not involved in previous sessions, I'll just briefly repeat a few matters. The agenda for the session was circulated a fortnight ago and is available on the DPA website under the case reference, which is WIN-130-10. Participants will be familiar with the format of a hearing session, so I won't explain that again, but I will just reiterate that my role is to understand and test parties' positions. So if I'm asking questions or probing on a particular point, this should not be taken as indicating that I necessarily disagree with what has been said. We'll be working from our own electronic devices or hard copies, so we may just need to take a moment to ensure that we've got the relevant documents in front of us. Hopefully we can progress quite quickly through the agenda and be finished relatively quickly. If necessary, we can take a break for lunch, or we may be able to conclude before lunch. We'll see how we get on. Before we move on to the main part of the agenda, are there any questions or matters to raise?
Nothing from me, sir. Thank you.
No. Okay. So we'll move on to the agenda. I think the main documents that we'll be referring to will, of course, be the tables of draft conditions. Sorry, I can see a hand up there. Apologies.
Friendly matter, thought it was appropriate to raise with you up front so the parties could see it. We lodged document 6.31, which is the Ladyfield decision. And while looking at that document, I've identified that it incorporates an EM condition. And we can obviously discuss that when we get to it. But I thought it appropriate to bring that matter to your attention right at the outset, because noises are a bit further down the agenda. And if parties, the council wanted to see that, it's 631, and in the it's the condition is the last one, which is condition 39. I'm presuming the council are fairly familiar with it, given that having read the decision letter, here's what has happened in this context, is that the council did not object to Ladyfield, and in their representations suggested that conditions should be attached. And that is what has happened in the ministerial decision. There's no discussion about an AM condition. And I thought it appropriate to let you and the council know up front about that, so that they could read that and they could take it into account when we discuss that agenda.
Okay, thank you. That's helpful to note, and we'll maybe take a look at that later on when we get to that point. But thank you for raising it now. So we will move on. As I was just saying, I think we'll be referring mainly to core documents CD 711 and 712, which are the track changes and clean versions of the conditions table, respectively. I understand these are based on the model conditions published by the Energy Consents Unit, but with various amendments to reflect the specific circumstances of this application and to take account of the views of consultees. And you'll see from the agenda that we'll also might need to take a look at certain consultation responses. And we'll obviously come on to discuss amplitude modulation and refer to the submissions made last week on that, which I'd like to thank parties for providing at relatively short notice. So moving to item 2, that relates to the timescale for implementation of any consent. And the applicant is seeking 7 years for implementation if consent is granted. That's the condition 2 under the section 36 conditions, and also deemed planning permission condition 6, and that's instead of the standard 5 years. And the applicant states that that's due to changes to the grid connection process. The council has indicated that it accepts that time period subject to satisfactory evidence or justification of why a longer period is needed. So what I'd like to do is just invite the applicant to briefly explain its rationale, and then I'll ask for the council's view on that.
The rationale, sir, is this. Current time for pre-reform, parties were able to make an application agreement either at distribution or transmission level, and would enter into an agreement and a date would be provided. What that's ultimately provided for those that are responsible for managing this process is a rather unwieldy queue where schemes sit in the queue and potentially don't come forward. And in terms of prioritising achieving the UK government's Clean Action Plan, it's been recognised that the current system that has operated hitherto in relation to grid is one that could have that ambition for the early delivery of capacity by 2030. As a consequence of that, there has been a review, and new procedures are now being put in place to effectively manage the situation. And as we currently stand, what is currently being undertaken is the review of the queue, and that will be dynamically managed. But what we do not know is what the outcome is. The distributions are going to be dealt with. There are so many more that have to be dealt with in that process. But thereafter, the transmission, the queue will be also subject to these arrangements. And what it means is that for applicants, there is an uncertainty as to when uncertainty is going to be achieved. And equally, with a more dynamic position, it may allow some grids to come forward and others not. And you just at this point don't know what the outcome is going to be. So it's created what we've had to describe as a fair hiatus in the industry. And that uncertainty is likely to persist for a while whilst these matters are resolved. And that also has played into essentially a priority being given to grid applications in Scotland, which you may well be aware that there's been published guidance relating to speeding up the decision relative to grid applications, given the importance of increasing the grid infrastructure to deliver the objectives. So at the current time, there is this hiatus and uncertainty, and simply we don't know how that's going to play out for this application and its declaration. And in the circumstances, whilst that is unresolved, we seek a kind of time period which we just don't know will be resolved.
Well, thank you. Now I invite the council to give its view on what's been said, please.
Thank you, sir. I think the council's concern here is that we're not familiar with any other consents having been granted with that period included. The 7 years it's a new period to us, and we're not convinced that the appropriate justification has been provided. It'd be helpful if clarification could be provided to explain why the 7 years is required. I know even the more recent consent for Ladyfield also stipulates a 5-year period. So it was just really to understand the 7-year period, because we're not aware of any other consents have been given that long. So that was where we were coming from on that, sir. Thank you.
Okay, thank you. Maybe and just invite the applicant to let me know if it is aware of any others with this time period on its.
No, sir. But what I would say is the issue about the queue management is a matter which is emerged relatively recently. It is part of the UK government's implementation of what needs to happen to deliver more capacity. What was just saying, deliver more capacity. It's managing the queue, and as I say, the issue there is you do not know at this point of time whether that management will benefit you or disbenefit you. So will be priorities given.
Okay.
Recent time will know. Ministers know this uncertainty. That's the reason why we're seeking 7 years. We just don't know what the grid position is at the moment, and it's really going to take some time to shake out in terms of official outcomes.
Okay. Does the council want to come back, say anything further on that, or we can move on?
No, I don't think so, sir. I think we've explained our thoughts on the matter. Thank you.
Okay, thank you. That's helpful. We'll move on then to item 3 on the agenda, which was relating to transports, and conditions 22 to 24 relate to transport matters. And having reviewed the recommendations of Transport Scotland, it appeared to me that these conditions do generally reflect those recommendations as set out in its most recent consultation response, which is dated 17th of June 2024, and that's in core document 1.240. But there's one point that wasn't clear to me whether it had been covered, which was Transport Scotland's recommended condition 5. So that's on PDF page 10 of that document regarding the proposed means of access to the trunk roads. And I was really just looking to understand whether that was omitted intentionally. For example, is it not necessary? I understand that the main site access is from the 819, and that's not a trunk road, but that there would be access for abnormal loads, I beg your pardon, from the A83 trunk road on a temporary basis. So if I could just invite the council to give me its views on that point, please, and then I'll ask the applicant to respond.
Thank you, sir. At the time of writing the report of handling, that response wasn't available to the council in the ECU case file. I've now had sight of the response, which is dated 17th of June 2024, and it was attached to the CD list at your request, sir, so thank you. It's our view that the condition is necessary, and in my opinion, it's not encapsulated within conditions 22 to 24. The access is referred to, however, in condition 18 for the SEMP. However, condition 18 does not require consultation with Transport Scotland, and the Planning Authority would have no objection to this being included as a standalone condition with a requirement for consultation with Transport Scotland if that is preferred. Thank you, sir.
Okay, can I invite the applicant to let me know its thoughts on that, please?
Yes, so we agree there's a look in relation to that too. And Peter, can I be that with the council suggested alternatively, minor alteration to the traffic management plan under item I, which already had details of how the abnormal load access on the A83 is to be controlled. And it could actually be slightly altered to say details of the abnormal load access from the A83 and how that is to be controlled. And that would then be specific and would also be the plan which is to be consulted with Transport Scotland. So I say we agree that should be needs to be amendment to one of the additions.
Okay. I mean, it may be that depending on where we get to with other agenda items, that it might be helpful just that there's a further round of discussion between the two parties if there are minor amendments that we're discussing today. So I don't necessarily have a strong preference over the two suggestions that have been made. Does the council want to say anything further at this stage?
No, sir, we'd be happy to do that at a later stage if that's what you would like us to do. Thank you.
Okay, that'll be fine then. Thank you. We will move on then to item 4, which again is picking up on a consultation response, in this case from Scottish Forestry, which is core document 1.221, and in particular the recommendations on page 3 of that document, which includes a request for a native woodland plan, including plantations on ancient woodland site survey and a revised assessment of compensatory planting area relating not only to the area to be removed, but also the ecological value of the plantations on ancient woodland sites, native woodland and ancient woodland proposed for removal. So I'd like to ask for parties' views on whether these recommendations are addressed by either Section 36, Condition 5, or deemed planning permission, Condition 30. And can I start with the applicant on this one, please?
Yes. Could I perhaps start off dealing with the general issue to raise, the general concern? In terms of Appendix 4.1, CD 171, there's a statement within the Forestry Appendix 10 Appendix identifying that compensatory 3.77 is required. And it's one short. And next to that, in addition, that is also submitted by CD 1188. It is a minimum of 3.77 hectares of woodland land is required. However, it notes significant opportunity areas that would be much greater than 3.77 hectares, and that therefore there would be opportunity of paragraph 164 plants substantially more than the figure. Indeed, on the indicative points, there are several times more. 164 of CD 188. So the applicants through the process were committing to more than 3.77 hectares of planting. And the planting associated with the rural planting, riparian planting, as opposed to commercial. And therefore, that I think where the criticism is made is possibly only having regard to case 4.1. There are wider commitments to planting, which would be planting which was directly responding to the biodiversity issue, seeking biodiversity enhancement. That's really the objective of this approach. In terms of the analysis, it's clear that the correct tradition to deal with the understanding of the nature and characterization of woodland that is to be found, and how you've mitigated it is to take conditions into Scottish forestry consultation condition, and it deals with the felling. We're going to provide a forestry building plan, details felling and its characterization. And that's the fundamental point. So the felling plan needs to characterize the woodland as supposed to be felled, restocking proposals. It also needs to detail management measures to reduce the amount of felling required to accommodate the development. So in terms of those two aspects, it's to specify firstly what you're proposing to fell and its characterization, and secondly, how you reduced the amount required to accommodate. So those two measures, cause issue will be picked up because it is a characterization. And also to see how we've sought to avoid it as well. And that would be one of the aspects of the detailed design scheme, is that you would be demonstrating how you've sought to reduce the felling and the impacts. Then we get to having approved that. There would then be an agreement on the felling and agreement on the restocking. The Scottish ministers have a woodland policy, and so they would then have to approve the essentially the restocking as well under their reference. In terms of Scottish Forestry's position, they would have been involved as a consultee and approving or consulting on the felling and the restocking at the stage of the activity. As we've already identified, the evidence implicitly is committed to moving more purely arithmetical restocking level.
Okay, thank you. I mean, I think if I understand your position, it's essentially that these comments from Scottish Forestry would be encapsulated within how that condition would actually operate in practice. Can I invite the council to comment on that, please?
Thank you, sir. And I think the council acknowledges that there's no specific reference to native woodland or pause, and if that was preferred, we'd be happy for that to be referred to specifically in the condition. Other than that, we're confident that the plans are required to be agreed with Scottish Forestry. So I don't have any other comments, sir. Thank you.
Okay, thank you. That's helpful. Just another point before we move on from this condition, which was condition 30, part G, suggests inserting reference to any local woodland strategy. And I just wanted to confirm with the council whether there's anything to be included here or whether that part of the condition should be deleted.
Thank you, sir. No, reference could be made to the Argyll and Bute Woodland and Forestry Strategy. which was April 2011 and is available on the council's website, sir.
Okay, thank you. If the applicant's agreeable to that, that's a change that could be picked up in a revision. Does the applicant want to say anything on that before we move on? No, okay, that's fine, thank you. So item 5 on the agenda, just a relatively minor point in relation to condition 31 on archaeology. Just a simple question as to whether the West of Scotland Archaeology Service ought to be included in this condition wording as a consultee. I've noted that the Council's committee report indicates that it has to be included as a consultee, and Chapter 10 of the EIAR does indicate an intention to follow the guidance of that organisation. So can I ask the Council for its view first, please?
Thank you, sir. Any details submitted pursuant to an archaeological condition, we will consult with the West of Scotland Archaeology Service on anyway as our advisors. So we're happy for them to be referred to in the condition if that's the preferred option, sir. Thank you.
Okay, does the applicant have any strong views on this?
I don't have a strong view, so but I'm not sure WSAS is actually a public body. I think it offers services to places. So, there's all these things. Whether they're used by the ICE, if it's an advisory service, it would normally be consultee, even though the council and they report to committees because they are given that advice. Council to anybody for advice, WSAS consists whatever. It's I don't think it has the same status as a full body.
Okay, that's fine. That's I understand the positions there. So we'll move on then to noise, item 6, which is condition 33, which is really the main area of disagreement between the two parties, and specifically in relation to whether amplitude modulation, or AM for short, should be addressed. So thank you again for the written submissions on that. I'll just sort of summarise my understanding of where parties are. So I understand that the Council considers amplitude modulation could occur and it cannot be reliably predicted in advance. It believes current policy is silent on the need for AM to be addressed by planning condition, but there's a body of evidence confirming the need for such control, and it is needed in this instance on a precautionary basis, and therefore it meets the tests for planning conditions. On the other hand, the applicant submits that predicted noise levels from the proposal are low, and there's no evidence to suggest AM would be an issue in this instance. It argues that including AM in a condition would be contrary to current policy, and this has been the finding in other cases. Such a condition would not meet the tests for planning conditions, and moreover, there are other means of addressing this issue, namely statutory nuisance powers. So I'd like to invite parties to firstly confirm if my brief summary of their case on this matter is accurate, and then perhaps just to expand and explain the key points in relation to their respective positions. And I'll invite the Council to start, please.
I was expecting Mr. Perkins to take over there, but he's disappeared from the
screen.
screen.
We'll give him a moment and hopefully he can join us again.
Button.
Yes, quite possibly. The leave button is quite close to the microphone button, unfortunately.
Yeah.
We'll give him a moment.
The climax there, I think.
Can you hear me, sir?
Yes, welcome back.
Apologies for that. My team's just completely died. So to answer your first question, yes, that is a reasonable summary of the council's position. In my position statement submitted last week, what I pointed out was that there is provision within ETSU R97 itself for looking at amplitude modulation as an issue. So I don't necessarily think that it needs policy support to have an AM condition. Obviously, it's lovely if it is there, but I don't think it's absolutely necessary that it's there. There is conflicting information out there. As rightly said, you can pick up a number of cases where AM has been included. You can also pick up a number of cases where AM has been dismissed. I don't believe the evidence for dismissal is sufficient. And in this particular case, it's more to do with the cumulative levels rather than the individual levels that are of the concern. In terms of where current, the current evidence is, as I pointed out in my note, there's a lot of evidence out there now. There's a lot of reports looking into AM. And the recommendation from the 2016 report commissioned by government, to which I was one of the authors, recommended that an AM condition should be made. You'll also be aware, and there's a note on the Scottish Government website, that there is a current review of ETSU R97 that's currently underway. I was part of that consultation group, and whilst the final document output from that process is still in front of ministers being considered, I can safely say that the consultation meetings that I went to, the AM condition was considered to be a fait accompli. Now that there's no reason to object to it. The reasons why in the past that may have been the case is because developers didn't understand what it was, how it was caused, and what they would need to do about it, and that presented a real risk to the development. But what I get from all the developers that I deal with now, they're all confident they know what it is. They can't necessarily stop it from happening, and it still remains the case. We cannot predict which sites where it will occur and how often, but where it does crop up, what the council does need is an effective means of making sure that AM condition can be activated, and so it can be investigated in a timely manner. I would accept that statutory nuisance is there and can be used as a fallback, but those cases I've been involved in and I've been aware of, the time scale required to undertake those cases is far longer than what would be considered necessary under a planning condition investigation of said matters. And as a result, the cases either don't get investigated properly, they don't get a resolution, or where they do, the council does feel that there's strong enough evidence to use statutory nuisance. And when I say that, although officially they don't say it, there is a public interest test that all councils apply in those situations to say how many people are involved in the public interest for us to do that. And I'm aware of a number of cases where they just conclude, no, it isn't. We haven't got the money to fight the developer on this, so they don't take it any further, and therefore there's no resolution to the case. Whereas where AM conditions are put in, there's a very swift swift conclusion that either is AM and it can be dealt with, or there isn't. So it provides a much more satisfactory control for the council to enable them to do it. And as I said, without betraying any confidences, that is likely to be the proposal in front of ministers at the moment, that the AM condition is accepted as policy. But as I said earlier, I don't believe it needs to be have policy endorsement for it to be. It's still within the spirit of what ETSU provisions there are, and ETSU itself is supported in policy. And there's plenty of examples and a recognised metric that the industry can use, and that's been accepted.
Okay, thank you. I'll invite the applicant to respond on what's been said, and then I may or may not have some follow-up questions.
I'll just deal with one matter that Mr. Councils have a statutory duty to inspect the area of nuisances. So if councils aren't fulfilling their legal obligations, then they can be held to a range of measures. Statutory nuisance has been used in a Scottish context for dealing with air. It's using recent Lincolnshire where it was raised in effect. That's a matter that ultimately goes to a sheriff court if there's a dispute. And received the notice. And the sheriff was quite happy to accept evidence on the character of the noise and to find that a nuisance existed. I think it would be fair to say, within the Scottish context, there has not been a significant number of cases where it has been held and appears to be an issue. That's one of the issues in terms of the necessity of a condition, as opposed to leaving it to the statutory regime that already exists and does operate. So, in terms of the current policy position, I think the onshore wind policy statement is very clear. It understands that there is ongoing further considerations being to update advice, and it recognises there may need to be a change to the approach, to the current approach, should that happen. Until that happens, the Scottish guidance talks about both the R95 is to be followed, and the approach is one approach. There has been also referenced like IOA good practice, which also does not recommend a condition as it currently stands. Against the 4 paragraphs then onshore for the statement 3.7, in my submission clearly recognise that if there is to be a change, that will have to occur at a time when there is an accepted position. And so that is the policy. The other general point is that when this is debated at length, and I don't think we are proposing to select in terms of today's hearing, there are still ongoing matters in the refinement of draft conditions relevant to this matter, which continue to be a matter of debate. And there's one I just want to flag to you, which I think is a matter. I think it's CD 9.4. It's the statement from the case where it includes a copy of the draft condition, which is placed for AM. I think it's probably like a few different formats, but I think the condition's the same. Suffice to say, the background to this is the council, in its first iteration of a draft condition, proposed, which was essentially to agree a future scheme. We have flagged in our response through the whole year report of noted to be clear, which is CD 1234, that we concerns about the specificity of that meet the tests. We did provide an alternative condition, which attempted as an alternative, but we didn't obviously support it. There is one continuing issue, and that's cited at the bottom of note 5A, and that is that relates to the following. The cases where the AM penalty and the tonal penalty relate to the same characteristic, e.g. amplitude modulated tones, and the sum of both penalties may overly penalise the characteristics of the noise. Such cases should be identified and penalised following the approach to the defined protocol. And that continues to be an issue because that is undefined too, because there's yet to be, as I understand it, a consensus on the issue. And that's exactly why this matter should await the formal publication of further consultation, guidance, or approved matters so that these can all be resolved. As I say, these matters remain to be potentially debated to ensure that the position doesn't take an over-aggressive approach in relation to the issue as well. So let's say that's a position. I don't really think I've got anything more to add to all the material that we have. I think you completely accurately summarised it at the outset, sir. And there's nothing really that I can add to that at this stage. So thank you.
Okay, thank you. I'll invite the council to respond if it has anything further to say on that. I suppose the other question that I will just pose at this point is just to understand views. The applicant submitted an extract from the Eric Isle decision, and I suppose I just wanted to know views on the extent to which the circumstances of that case are comparable to this one. But I'll invite the council to respond, and you may want to pick up that additional point, and then I'll come back to the applicant.
Certainly, sir. I was the expert giving evidence in that inquiry as well, so I'm very familiar with that case. The noise levels in that particular case were lower than being proposed here, and they didn't have cumulative situations where the levels would be potentially substantially higher. So I would submit that the position of that case was different materially to this one, where the cumulative levels are substantially higher. I would also point out that in terms of including this as a condition, obviously from the council's perspective, we get one shot at getting a condition in to cover amplitude modulation. If it's included now, the developer has the opportunity, if there were further enhancements or call them tweaks to the guidance when they eventually appear, assuming that they get adopted, then there could be a submission made to vary the condition. If you choose not to put the condition in, there's no further option for the council to get AM put in retrospectively, and it would fall back to, say, the statutory nuisance provisions, where the burden of the evidence then falls to the council to find rather than the developer, which is out with the spirit of the ETSU standard, where the investigation, which is complaint-led, and I'd just emphasise that point, this is not a control for AM well, it lasts for the duration of the wind farm, but it's not that they have to go out and police it every single day. It's only in relation, it's linked to the complaint methodology. So it's only a case of saying where there is a justified complaint and the council asks you to go out and investigate, we want you to look at the AM element as well, in exactly the same way that the tonality aspect has been included in ETSU and it's never been challenged for many years. And I would contend that the AM is just an extension of that tonal penalty for acoustic character, which is within the spirit of what ETSU provisions are already there.
Okay, thank you. Is there anything that the applicant wants to come back on what's been said just now?
Nothing of substance, but there obviously was no disagreement with the fact that AM doesn't appear to have been a major issue in Scotland.
Okay. Any further points in relation to AM then, or can we move on from this agenda item? That's fine. I think I understand parties' views. Now, I'm sort of conscious of time and where we are on the agenda. There's really just the one item. It's 1 o'clock just now. Are parties happy to push on to cover the last item and then finish before lunch? Yep. Okay. in which case we will move on to item 7, which is ornithology conditions. And I'm conscious, obviously, Nature Scott is not here participating in this hearing session, but I thought it would be helpful if the applicant could respond today to Nature Scott's written comments on conditions so that I can understand the extent of agreement or disagreement that remains. And I'm happy for any input that the council may wish to make on these conditions as well, for example, in relation to enforceability. So Nature Scott made comments relating to conditions both in its further written submission response of the 2nd of May and then in its subsequent response dated 16th of May, and I'd asked it specifically to look at the conditions there. So I've sort of got a note here summarising what I think the main points are, and perhaps I'll just sort of list those out and then we can go through them, or I can repeat as necessary to make sure that we've covered them all. But as I see it, the main points that Nature Scott has raised are, firstly, whether condition 28 is intended to relate to both nest sites, which is part 3 of that condition, and then also part 3 of that condition, the implications of reference in it to the breeding periods, given the potential in Nature Scott's view for disturbance to occur at all times of year. Then there is a point about the potential implications for roosting birds of construction hours of 7 AM to 7 PM, which is in condition 21, and blasting hours of 10 AM to 4 PM, which is in condition 20. I think that comment was in the earlier of the two responses. Whether a burning regime referenced in condition 26 part 2 would be appropriate as part of a restoration and enhancement plan. And then a point about collision monitoring and whether that ought to be moved to condition 29. That's on the basis that condition 28 is titled Bird Protection Plan. Part 2 of that condition refers to bird and bat collision monitoring. So there's a suggestion that the scope of condition 29 could be broadened to refer to monitoring more generally, not just golden eagle. Then there's a point made about the importance of access to tagging data in terms of monitoring. And then I suppose there's an overall concern about the adequacy of condition 28 in light of Nature Scott's concerns. I suspect that one in particular we can't resolve today. I realise that that's quite a few matters that I've just run through, so I'm happy to go back through and take them in turn. But it's really just to understand to what extent the applicant agrees or considers that it might want to make further changes in response to that. So if I can just invite some comments from the applicant, please.
Yes, thanks. In terms of, I'd also noted a range of matters that Nature Scott had was on. I also had the apology condition 25, where they reserve their position, and of course that's a document to be submitted and approved, and therefore I think that's a matter which the petition should also incorporate a consultation with Nature Scott. That's 25. It's probably produces outline, and we fully appreciate as we get to the detail of things, it would be a matter to be in terms of there was 2 points: moving the bird protection plan monitoring from condition 28 into 29, so that it would become golden eagle and other ornithological monitoring makes sense. So we agree that it would be sensible to take 28.2 and take it down into 29 and to have it as a 2 and it become golden eagle monitoring of what golden eagle and other ornithological monitoring. And actually, it's actually a mammal as well.
Yeah, I think it's broader than just ornithology. I think it's just monitoring in general.
So we'd have that as 2 and leave the bird protection plan in its current form. So those were the changes. Then the question is, does 28 cover both nest sites? Yes, it's a blanket protection plan that covers it all. So irrespective of which nest site were to be selected, if any, they would be covered by the policy or the condition. And it covers the point of even finding. The difficulty with here is we are due to other legal regimes. At the end of the day, the golden eagle could choose a third nest. So it needs to be protected. And there are legal regimes to do so. I suppose here what we're doing is ensuring that it's managed and that we're accountable for it. And this covers all nests. So that's nesting. Then there's the Nature's got issue about roosting, and we've submitted evidence to New Zealand, which is data available from the tagging of particular eagles in this location. And that gives us the direct evidence as to the nature and extent of roosting, and a very large number of roost sites. Golden eagles this range use. And this, I think we've sensitized is some thought for that golden eagles are reliant on a relatively few number of roost sites. In this location, our evidence suggests that that is not the case. Now, that doesn't mean all golden eagles will follow this pattern. This may well be specific to this range, given the number and wide range of roosting sites which are available to them. So it's not a general point we're making in response to this, it's the specific point. And therefore, if you don't have this very specific, it's very hard for Nature Scott to suggest that birds would be harassed given the range and nature of roosting sites that they would have available to them. And we've also, the vast majority are out with distance they are suggested should be applied. So we don't think the planning system should be intervening in this matter because of the evidence that we put forward in relation to the matter. So we don't suggest there needs to be additional action dealing with roosting. Because, as we say, there's evidence in relation to the matter. That covers off the hours and the concept of harassment. And it's clear that the nature and concept of harassment is an important one for some areas. And it's to do and have enforcement mechanism against deliberate reckless attempts to move on golden eagles, which some people might try to do. And our activities in terms of construction are, of course, going to be monitored throughout the process by an eco. And these are the sorts of matters which, if there were any matters that were of concern, would be considered and steps taken. So the whole process of our construction is not one which is not subject to monitoring. So there is also an active position that we take regarding the ECO's role in that. I don't think the evidence suggests that it is necessary to have a condition.
Okay, thank you. That's helpful. We probably can't take this a lot further today. The only one that I just wanted to come back to was the point about a burning regime that Nature Scott had raised, which is referenced in condition 26, part 2. And I think the suggestion from Nature Scott was that they don't necessarily consider that would be appropriate as part of a restoration and enhancement plan. I just wanted to give you the opportunity to say anything about that today. Just in terms of locating that, it's in core document 11.11, which is the 16th of May document, and there's a section on conditions 25 and 26.
Yeah, I've got the specific. It doesn't permit burning. It says, if people didn't want it to happen, they could just refuse the area that incorporated it. It is one method of carrying out restoration. And in terms of what is said, is they don't think, well, I don't think you should necessarily prejudge that stage. It will be controlled, and it won't be effectively, as mentioned, sensitive burning, not some rights down. I suppose there is a sensitivity about this in Scotland because over the last period of time, we've had problems with fires, and we have had problems with violent fires and also fires. I understand the sensitivity. This would only be undertaken. It's authorised and got the necessary. In terms of the actual cane itself, there are alternatives to burning which are cutting, and that can be clearly. It's not going to the heart of whether we can deliver it. It's what would be the most effective, and we wouldn't want it necessarily excluded at this stage. We'll understand and then go to the sensitivities.
Okay, that's fine. Does the council want to say anything in relation to the matters that Nature Scott has raised?
Yes, please, sir. Thank you. Only really to say that the council supports Nature Scott's input on the draft conditions and their recommendations as expert advisors. Thank you.
Okay, thank you very much. Just find my agenda. We're at item 8 then, which is any other relevant matters. I don't have any further matters to raise. I don't think there's anything that's cropped up this afternoon that we haven't come back to. So I'd just like to invite parties, if there's anything in relation to conditions that we haven't covered that you want to raise before I move on to some closing remarks. Nothing from anybody.
I would just like to finish the hearing sections that we've had. So obviously like to thank your team for the organisation. The role has been excellent. But also have to recognise that we've had quite a lot of dialogue behind the scenes with the council, and just to recognise we've had very positive dialogue. It's very helpful in narrowing issues, agreeing conditions, and there's actually been a lot of work done up front. And I just want to mark that to thank the council and their team for that level of cooperation, which has certainly been really helpful in presenting information to the last 2 days of hearings.
Okay, thank you. That's noted and good to hear. So in that case, I'll just move on to a few closing remarks and a few matters just to cover off. So that's the conditions hearing session closed. Thank you everybody for your input. And as you'll be aware, I mentioned it yesterday, we do currently have one further hearing scheduled on ornithology on the 21st of August, which would involve the applicant and Nature Scott. I will consider the further written submissions on this matter in due course and determine whether I now have sufficient information on this topic, whether I need anything further in writing, and whether the scheduled hearing on ornithology is required. So I'll provide an update as soon as possible via the case officer on that. In light of the fact that the ornithology hearing might not ultimately be required, and also the fact that the council doesn't intend to participate in it if it does take place, I'd like to just discuss arrangements for case summaries and closing submissions now, which we briefly touched on in the pre-examination meeting in March. As parties will be aware, closing summaries are a standard part of the inquiry process, allowing parties to summarise their overall case, including in relation to the evidence heard at any oral sessions. Case summaries are intended to help speed up the process of writing up reports for ministers, as these would be included as an appendix to the report, rather than me having to write my own summary of each party's case. And we can circulate templates for case summaries within the next day or two, although I suspect parties have probably seen them before on other cases. Practice has tended to be that case summaries and closing submissions only address matters covered in oral sessions, not all other issues. So although I will not be formally closing the inquiry today, given that a further hearing session may be held in August, in the interests of efficient handling of the case, I would propose that closing submissions and case summaries on the topics we've covered this week should be provided at this stage, with the council having 2 weeks from now and the applicant 3 weeks from now, which would be the 12th and 19th of June, respectively. And then if the ornithology hearing does take place, further closing submissions and case summaries addressing that topic could be provided later. So I'd just like to hear parties' views on what I've just outlined in terms of process and the dates. Please start with the council.
Yes, sir, thank you. Talking process, Ms. Knox has very helpfully provided the documents I referred to earlier already, and I will send that on to you and to the applicant team straight after lunch today. Thank you very much, Ms. Knox, for doing that. And also the closing submission date for the 12th of June is what I anticipated, and thank you very much. We'll be able to adhere to that. And also, I'd like to just finish off by thanking the Ship and Wedderburn team for their cooperation with the council, and in particular for their very prompt dealing with the core documents list, which is extremely helpful.
Okay, thank you. And anything from the applicant in terms of what I've just outlined?
I'm very happy with what's proposed there, and it's very sensible. Otherwise, things just get lost. So it's much more sensible to have this done now and to have those submissions done. I'm very, very, very pleased that we're doing it this way. Thank you.
Okay, thank you. Any other matters or any questions at this stage before we finish the meeting? No. Okay, in that case, thank you everybody for your input today and yesterday, those that were involved, and